Deputy Fire Chief calling for that examination, and another one recalling for fire records clerk because they were unable, and I'll give you the letter, they were unable to fill the position because of
Has anybody seen the extra agendas or the only voting meetings?
they are outside.
Yeah, they should be getting them out.
Oh, okay, good.
Thank you.
Joel said to quit time when I get on. I'm trying to tell you.
guys ready? All right, I'd like to call to order this board meeting of the Municipal Fire and Police Civil Service Board on August 23rd, 2021. Before we start, let's call roll first, and then we got two add-ons to do. Ms. Penny, will you call roll, please?
Sharon Lewis. John Smith. Brandon Williams. Chris Robinson.
Present.
Floyd Falcon. And Rob Marisi.
Present.
You have a quorum, sir.
Thank you, ma'am. We have two add-ons. First add-on is going to be calling for the test for Deputy Fire Chief. That's been requested by Chief Majors. The second add-on is calling for Fire Records Clerk. We had called for that before. He was unable to fill that position with the current list that he has, so he's asked for us to call for another test at this time. I move to add the request for Deputy Fire Chief exam to item number C1. I need a second on that.
I'll second it.
Seconded by Dr. Robinson. All in favor signify by saying aye.
Aye.
Any opposed? Motion carries. I move to call for Fire Records Clerk, call for the exam for Fire Records Clerk as item number C2, seconded by Mr. Smith. All in favor signify by saying aye.
Aye.
Any opposed? Motion carries.
You know what? Our internet was down.
Yes,
That explains why you do that.
Probably.
for a whole day.
I knew it was odd, but, you know.
That's what it was.
Has everybody had a chance to review the minutes, from the July 26th meeting? And is there anything to add to that? Were you satisfied, Dr. Robinson, with the way that we were going to call for something? I remember you had an amendment at the time. Or that might have been on the minutes for June.
Do we have them in?
I'm looking.
Oh, from last month?
Yeah.
Yes, ma'am.
I said that's Oops.
We don't have a copy of them here.
I just put in the most recent.
Yeah, I didn't see it.
They were approved as amended.
You'll be able to explain that for us? Where is that at? Oh, you need to add it on? Okay, so that's going to be add-on number 3? All right.
Okay.
That's to extend. I'll let you say all that. We have one more add-on. Second one was the third add-on is going to be to a request by the fire department to extend Chief Major's provisional appointment to a certain date because 90 more days. It gives we'll talk about it then. I move to, let's see, that's going to be provisional appointment. Item 3D, I move to add that item onto 3D, D, Delta.
Second.
Seconded by Dr. Robinson. All in favor signify by saying aye.
Aye.
Any opposed? We will
Who
talk
made
about-
that motion, please?
I did, seconded by Dr. Robinson. And that was for the extension of Chief Major's provisional appointment. All right. Does anyone have any issues with last month's minutes? Anything to amend? I move we accept those minutes.
Second.
seconded by Dr. Robinson. All in favor signify by saying aye.
Aye.
Any opposed? Those minutes are accepted. Administrative matters, item 3A. Approve applications for police sergeant and criminal intelligence analysts. I'll pass these out to you guys if you'd like to take a look. We have approximately 104 police sergeant exams. And,
I don't think they want to see those.
and 7 criminal intelligence analysts. Motion made by Mr. Smith, I'll second. I'll hold the vote off so you guys can see them. Do you guys want to go through these?
They all qualify, haven't
Not
they?
yet. I didn't apply.
She said all the applications qualify though.
Yeah, we didn't have any disqualifications.
They're on paper, they have a legal signature, so.
The requirement for that is solely that you're here a certain amount of years. That's why there's no educational, it's an easy one. As long as there's a driver's license and a proof of citizenship. Sir, Dr. Robinson, do you want to leave? All right, all in favor of accepting those applications for police sergeant and criminal intelligence analysts signify by saying aye.
Aye.
Any opposed? And we will accept those applications. Item 3B, approve scores for police fingerprint technician 2, fire safety officer, and police criminal information specialist 2. Those should be in your packets if you would like to review them.
No.
Looks like fingerprint technician 2, we have 1.
Let me get back to
Looks
the
like
civil service board meeting.
fire safety officer, we have
Call back since I'm out.
9
Okay, all right.
passing scores. And police criminal information specialist 2, we have 1 passing score. I move that we accept those scores. Seconded by Mr. Smith. All in favor signify by saying aye.
Aye.
Any opposed? Accept those scores. Item number 3C, call for examinations. I'm going to list off the examinations that we're going to call for. These will not include our add-ons. Budgeting and accounting administrator, is that a fire position or a police position? Fire, okay. Research and statistical analysis officer, fire as well, okay. Police cadet, police criminal information specialist 1, and police communications officer 1.
In the letter received to request these exams, that was not specific, but it was for the fire department.
Perfect, thank you, ma'am. I move to call for these examinations.
Second.
Seconded by Mr. Robinson, Dr. Robinson. All in favor signify by saying aye.
Aye.
Any opposed? Add-on item number C1, a request by the fire department to call for deputy fire chief. I move that we call for that test. Seconded by Mr. Smith. All in favor signify by saying aye. Any opposed? Motion carries. Item number C2, request C2. I'm sorry, I misspoke. C3, C2. C2, we have C1, C2. C2 is a request by the fire department to call for a test for fire records clerk, and I'll let Mr. Smith explain that real quick. I move to call for that test. Seconded by Mr. Smith. All in favor signify by saying aye.
Aye.
Any opposed? And we will call for that test. Item number 3D. Please do.
I move that we extend Chad Baker's fire
you turn your microphone on, please?
Mike?
You need me to say it again? I move that we call for an extension of 90 days to Chad Major's appointment as fire chief for his provisional appointment.
Is that just to give the mayor time to hire a new fire chief?
That's right.
And when were the exams given for that?
August 3rd.
Have the results come in yet?
No.
Well, obviously not.
No, I hadn't seen it yet.
I second that
It
motion.
It gives her time, gives the mayor time to make her appointment.
Is she gonna conduct interviews and everything?
Yes. Well, I hope. Yeah, she should.
I second that motion. All in favor signify by saying aye for the 90-day extension.
Aye.
Aye.
Any opposed? And the motion carries. Mr. Floyd, do we have a legal update today?
To do a couple of things.
Is your mic on?
First,
Put it in the stack form. Sorry.
in the recent hearing we had on John Dossier from the suspension, he filed a petition for judicial review. Nothing even said in that matter yet, but it's pending in the 19th judicial district. In connection with this Asida Real, hearing we had, there was an appeal. Creel. There was an appeal, and the board, reduced the disciplinary action appointed by the judge. Mr. Creel had appealed, Judge, Chip Moore, rendered a decision dated, I got it Thursday or Friday, reversing the board's decision and reinstating in toto, Mr. Creel to his former position. There was one troubling thing from my standpoint, or from his board's standpoint. The board is not a party to the suit. The appeal is an appeal by the individual officer, and the opposing party is, in this case, is the Baton Rouge City Police, since he was a policeman. Judge Moore charged court costs to this board. We're not a party litigant, we're in a judicial capacity deciding the case. So I recommended, I called it to the attention of the chairman, and I had a discussion with the parish attorney, suggesting to the parish attorney they might want to, that I thought that was improper, and that we might want to appeal, that we might want to have the city authorize an appeal of this matter to the district court, because if you recall, in the Creel matter, it was taken down in transcript. The transcript, Penny, you remember what it was? It was about 1,000 pages or so.
It was
6,000.
reduced.
6,000.
Go ahead, John.
It was 6,000 pages
Yeah.
from the girl that sat up here and did the transcript.
Well, it was a lot. Anyway, the cost of the appeal is gonna be multiple thousands of dollars, and that was tagged to the board. Seems inappropriate to me. I recommended to the parish attorney that he might wanna look at that and see if they wanted to appeal. And, he told me initially no. Second time he talked, he's gonna look into it a little bit more. So I went ahead and sent, he didn't have the decision yet, so I went ahead and sent him the decision either Thursday or Friday last week. So I don't have I don't have the final information from the city what they want to do. It's my understanding, this board doesn't have any funds in their budget
I was about to
in
say.
court costs,
Right.
much less thousands of dollars in court costs. The concern I have is that the board is serving in a judicial capacity. It would be the same thing as if the 19th Judicial District Court, one of the judges here would render a decision reversing a litigant in an automobile accident, any type of civil action. It goes to the Court of Appeal, the Court of Appeal reverses, and the Court of Appeal makes the judge pay the court costs. I don't believe that's ever happened to my knowledge in the state of Louisiana. But that analogy is exactly right. We served in a judicial capacity, the 5 members of the board served in a judicial capacity. They made a decision that decision was reversed. You know, actually, the court cost should be assessed against the losing party in that case. For some reason, Judge Moore assessed it against the board itself, which,
Well, we're not a party to the suit. So,
you're not a party litigant.
right,
We
exactly.
have a different role. I think court cost is assessed against the losing litigant.
What's the worst case scenario? I mean, if either the parish attorney's office
Decides not to.
decides not to pursue it, and if the 19 JDC decides that we will absorb those costs, or we'll have to go before the city council and request those funds, or?
I would suspect we would, yeah.
Well, I look forward to hearing from you about it.
But that's the two matters I had from a standpoint of legal report.
Thank you, sir. We have a motion for extension of time for Corporal Donald Steele's investigation. I spoke with Mr. Floyd. I received that, or we received that earlier this week, maybe, I'm sorry, not this week, early last week. I spoke with Mr. Floyd to make sure that I could approve it without a board hearing. The reason being is that the date for the 60 days ended on Sunday, yesterday, and I didn't want to have to call for a special meeting for us to have to approve that. The law has changed in that before August 1st, a department, fire or police, had 60 days to conduct an investigation that we're all very familiar with. The law's changed to allow them 75 days now, and I think erring on the side of caution, Mr. Hamilton and Mr. Raines decided to go ahead and ask for an extension of 15 days, which would meet that 75-day rule because this case started prior to August 1st. And Mr. Floyd, I asked Mr. Floyd if he agreed that, I believe that they should fall under the 75-day rule personally, but because they hadn't met that 60 days by August 1st. But Mr. Floyd agreed that we should go ahead and consider the extension just to keep the integrity of the investigation correct. And all you needed was 15 days?
We actually ended up getting it signed on Friday. But we don't really need it. Yeah.
Oh,
I know
okay.
you signed it on Friday, but, we actually got it signed before the end of that Friday.
So you guys don't even need an extension anymore?
Right.
Okay.
So what's happened to the signature that you provided?
It goes away, it's not needed.
He said he signed the extension already.
It's not needed. I mean, it's already been approved. We can do away with it here as a board if you'd like to. I'm not concerned about it.
I was just gonna move that we sustain your signature, just as a formality.
That's a good idea from just formality.
Yeah, I'll make that motion.
I'll second that.
Seconded by Mr. Smith.
Please repeat the motion.
We sustain in Rob's signature of the extension.
And it was seconded by Mr. Smith. All in favor signify by saying aye. Before we go, I'm sorry, does anybody have any questions about that? What was needed? All in favor signify by saying aye.
Aye.
Any opposed? And the motion carries. We received a petition, item number 6, we received a petition of appeal for an officer, Jacob Cowart, which is a termination and a 40-day suspension. Did the 40-day suspension, is two separate internal affairs file numbers. So he received the 40-day and then as a progressive punishment received the termination after, I'm assuming? Mr. Dew, you're representing Mr. Cowart?
Yes.
Okay.
First conversations, I think there's a November date available. I'd like to file a motion for a summary disposition based on recent rulings on that November date to limit the amount of time that will be needed for the board. And if that's not successful, then they have a full evidentiary hearing, which I was next available, which I was told was March.
I see.
The fourth Monday is November 22nd.
That's for your motion,
That'd be a summary disposition motion, yes.
Mr. Kershaw, can you step up real quick? You have or had a client named Michelle Patterson.
Correct.
You guys were slated for the November date. Are you still gonna need that hearing date?
I will not, that's been resolved, and in fact, the conversation with her last week, that she would withdraw her appeal based on, it's resolved now.
Perfect. I move that we accept it verbally now, but can you shoot us an email just in writing stating that you've released that date, that she no longer requests to appeal, just so we can have it on file?
Okay.
We'll accept the verbal one now. I move that we accept the verbal rescinding of the request for appeal by Ms. Patterson on November 22nd.
I'll second that.
Seconded by Mr. Smith. All in favor signify by saying aye. Any opposed? All right. Now we have a November date opened up.
That works. That day would be the day I give the summary disposition. Hopefully it will be resolved. If not, we would then be requesting full evidentiary hearing. I think that you said the next available was going to be March. I would have a conflict in March. It happens to be my wife's birthday, a very monumental birthday, which I won't mention the number. I will not be here if I did mention the number. So maybe the April date, if it's not resolved on that November date.
Okay. I'd like the board to talk about this real quick. In an effort, and we'll talk more at length about these appeal hearings and their length. There's two issues that I think are before us, and that is you've made note of it quite a few times, Mr. Williams, that, we have this officer, prime example, Ms. Patterson, Mr. Dothier's letter of caution, it took over a year, years in some cases, for us to finally hear it. And then the other issue is how long these hearings are taking. As far as my idea for getting speedy hearings for employees is that we hear the motions on the same day that we could possibly hear the evidentiary information. Meaning, instead of filing in November the motion and we just discuss the motion, would it be too much of a burden on both sides to prep for the argument of a motion and also the hearing, the evidentiary part of the hearing? And it's just a way to expedite and not push so far down the line.
Well, you are presuming a result when you do that.
I'm presuming that the board will,
That the motion if the motion prevails,
correct,
then it's over.
and it's over.
Right.
But if the motion doesn't prevail, then we would be ready to move into the hearing, correct?
Now, the assumption is that the motion discussion, or even among you guys, is gonna be brief. It may or it may not be. It's not one. Preparing for the motion is not to me the issue.
I agree with the council in that, I know you'd like to expedite it, but also we would all like to, with the summary disposition, hopefully, without it, we don't know the outcome, we don't know how deep that discussion may get, if there's been any other additional rulings between now and then relative to some of the cases that will be cited. So it would be better to be prepared for one, instead of having many witnesses subpoenaed and here and sitting there and it become a moot point, and so many people have been inconvenienced to do the summary disposition, to see if we get a ruling and go from there, and then to do the full evidence hearing. I think it would be the best way to spend everyone's time involved, including all the witnesses that would be subpoenaed.
To separate the motion for summary judgment and the hearing, you agree with that?
Yes. Actually, the motion in and of itself can be done relatively quickly.
Mm-hmm.
Usually not, though.
The pleadings are filed, and what's before you is really argued. That could be done relatively quickly, but
What are your thoughts, Mr.?
hearing involves witnesses and the whole thing.
I think, for instance,
I would agree with what you said.
I think what council is saying is appropriate, because generally speaking, we should be able to dispose of a motion in 30 minutes or so. But the only thing is, what we don't wanna do is have a motion, and then that's the only thing on the agenda other than the administrative matters, and because we're behind, not have a hearing on the merits also scheduled that day. So if Mr. Coward, wants to have a motion and have it separate, and we go ahead and schedule, since Michelle Patterson is off the record, now we need to set a hearing on the motion, but, on, a hearing on the merits on another case. Whichever case would be next in line, or however y'all wanna do it, but we don't wanna waste that time, the 2 to 3 or 4 or 5 hours, whatever it would take, to hear a case on the merits. We should have that scheduled the same day as the motions in another case.
I agree with that. I think that's a good compromise. Yeah.
Hopefully it would be limited to, like you said, an hour or so or less.
We're gonna limit it for more than that if I have anything.
Yeah, yeah, we are.
Well, if we do this, we set up, when to do the motion and everything, we set up a briefing schedule. So it's not time frame for us to
Sure.
file everything, so that we have time to.
What's the briefing schedule?
We submit reports to each other and then to the board, so, and the board needs to send his motions in 2 weeks in advance of the hearing, and the response, fully importantly, one week in advance of that.
2 weeks.
2 weeks
For the
for the
appeal.
mover.
The mover.
It could be,
The mover, right.
the mover could be the
Either
city,
side.
or it might be the appellant, but in any case, what we're gonna do is set up, the board's gonna consider a briefing schedule where the mover in the motion, 2 weeks prior to the hearing on the motion, submits a brief outlining, what the basis of the motion is gonna be, and then the opposing party would have till 7 days before the hearing, or 7 days to respond.
Is that sufficient time?
Well, I can, I'll say it a little.
I think that's-
Right.
You can set up one case with it.
2 IA file numbers for Mr. Coward.
Yeah, we have two,
He's got 2 separate cases, so that's why we're gonna file 2 separate motions.
yeah, it'll be similar, but they'll be.
Yeah.
Whatever, I'm just throwing out to have it, set a time for the motion to be filed prior to the hearing, and when the response is due. Y'all want to do 3 weeks and 1 week,
15 days. 3 weeks and 1 week?
15 days, 30 days, we're still.
I think that's a board decision, not what he wants, isn't it? We trying to decide what we're gonna do is sort of establish a precedent.
Right.
In all cases involving a motion, a dispositive motion, that they be filed, whatever the board decides, X number of the days before the hearing, and the response be X number of days before the hearing. 3 weeks, 2 weeks, whatever y'all decide, whatever the board decides, but we would at least have that information in advance.
Well, we can make the decision, I'm just suggesting.
Are you worried that there's not enough time?
Yeah, it could be a trial week for us, and we.
I got you.
You know, when we file the brief.
So what would be better for you guys? 2 weeks?
30
3
days
weeks?
and 15 days.
15 days?
15 days for you, and we're talking about November, so we're pretty far out.
Yeah,
And if we choose to do that, I ask that you both let us know if, because we're gonna set a precedent here, and we're gonna use this from here on out. Let us know if that was enough, if there's something we could tweak, change, if it needs to be more, it can be less.
Council and see if they have any issues and let them know.
Perfect.
And obviously contact the board, just to make sure that, I think 30 days should be fine considering it's in November now.
Okay.
It's set in November.
I move to set the motion hearing for Mr. Cowart's 2 cases, yes, the motion hearing for Mr. Cowart's 2 cases for November 22nd, 2021. And that we, what are the names of those? The briefs?
The response, the opposition memorandum.
And that we have the opposition memorandum filed no later than 15 days prior to that date.
I'll have the motion filed 30 days.
Thank you, sir.
And give not
Would you like us, well, no, because there's a conflict for March. Would you like us to go ahead and schedule?
Yeah, and March had a conflict, so whatever, the April date is up.
25th, April 25th.
Motion.
Double check.
So do you,
April 25th
Do you need a second on that? Was that a
I
motion?
did need a second for the motion hearing
Yeah.
on the 22nd of November.
I'm gonna second that, but of course, my problem with the whole process is that when you file your motion and you come back and you do your argument, we hear the same things over again. You know, so it's, well, I understand, that's part of the process, but,
Mr. President, actually, it's gonna be more of a legal issue on that, and the other one will be evidentiary, where we actually have briefings, so I think it is a little bit different, I don't think it'll be redundant for you.
not as much as it should be, but anyway, I second the motion.
Seconded by Dr. Robinson. All in favor signify by saying aye, and just to clarify, this is for to hear the motion, two Cowart motions on November 22nd, 2021. All in favor signify by saying aye.
Aye.
Any opposed? And we'll be hearing that motion on the 22nd. Then we need to set a date for
Here.
the hearing itself, which will be April 25th. Is that correct, Ms. Benny?
That's correct.
Okay. Yes, sir. Is there any conflicts with you guys?
Involved, so.
We're gonna discuss that. We're gonna discuss that, and I think that the Camelot one, we're gonna have a discussion about it. And I haven't finalized how to start condensing what we do, but we'll discuss having multiple
But if
hearings
it
in one
came
day.
down, we had to take one of that option, we take the determination more serious of the two first, if they cannot be consolidated.
We'll talk about, we have enough time to talk about it between now and then.
Thank you,
Let's,
members of the board.
thank you, sir. Let's, I make a motion to schedule the two hearings on the 25th of April for Mr. Cowart. Seconded by Mr. Williams.
April 20,
April 25th, I'm sorry, did I misspeak? Cowart hearings. And that is for a termination and a 60-day suspension. 40-day, I'm sorry. Waiting for a second on that one.
Brandon, second.
I'm sorry. All in favor signify by saying aye.
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 Any opposed? And again, we'll discuss as a board between now and then, actually maybe much sooner than that, about trying to consolidate the time frame and stuff like that for these hearings. Termination, 40 day. All right. It's up to you. It's not on the agenda. We'll talk more about it. All right, that brings us to item number 7, appeal hearing for Kenneth Camelot. We have a 60-day suspension in motion. Okay,
No, 60-day suspension.
and a demotion. Right. It's a 60-day suspension, 65-day suspension, a 75-day suspension, and a demotion with some classes that the board needs to discuss. Initially, I had requested that we go into executive session so we could be counseled by our counselor, but he has recommended that we do this in public so that we, as a board, can be notified.
Let me give you all each a copy of the law. The situation we have, on the record right now, we have a documents that reflect that the pre-disciplinary hearing was held in 3 matters on April 29th, 2021. We have in the record the rulings by the chief. All 3 of rulings were on the same day, June 14th, 2021 was the day of the rulings. And then 3 appeals filed by Mr. Camelot, all filed 6/23/21. In the 3 disciplinary actions, the chief imposed, well, first of all, the charges in the first one was conduct unbecoming digital mobile video and audio equipment misuse and carrying out orders. And the second one, again, it was conduct unbecoming an officer and carrying out orders. And the third disciplinary action, again, it was conduct unbecoming and carrying out off orders. I'm told by Mr. Raines told me that the factual circumstances in each case are somewhat different, though they wanted to have three separate hearings on that. I want to call to the board's attention, well, first of all, the chairman called me one day, and questioned the relevance of RS 33-2500B, specifically subsection B, which provides unless a cause or condition justifies an employee being permanently removed, disciplinary action may extend to suspension without pay for a period not exceeding the aggregate of 90 days in a 12-month period. So, the chairman and I discussed what that might be, what that means, and he suggested that I contact the state examiner's office, which I did, spoke at length with the state examiner, and then had a conference call with her lawyer, who opined that a sentence that totaled 200 days in a 12-month period would be violative of RS 33-2500B. I had formed an opinion on that. Also, I reported the opinion of well, first of all, we also researched and we could not find a similar situation, and I don't think the city's found a similar situation where you have the imposition of 3 sentences that total more than 90 days in a 12-month period. So we couldn't get any guidance from the existing jurisprudence, and that's why we went to the state examiner. They told me also that they had looked at that and at the same time was of the opinion that there was no guidance in the form of jurisprudence on that issue. So the chairman and I discussed that further, and we decided we would put this matter before the board to determine whether or not imposing 3 impositions of sentence or 60 days, 65 days, and 75 days in succession, or a total of 200 days in a 12-month period was violative of 33-2500, and I think that's the discussion he wants to have at this point. In order to do this, and so everybody, if there is an appeal by either side in this, we would want to make note that the record right now includes the decisions, the decision of the chief in each of the 3 chiefs ruling body. The three decisions we would want to be part of the record in this matter. The 3 notices of disciplinary action being part of the record, and the 3 appeals being part of the record. So you're going to have those documents to rely on, all of which are already part of the record that we have at the board. And that's where we stand.
I'd like to open it up to the board for discussion, and I think there's another part to that, or is it even worth mentioning about the notification, the 1980C's findings, and the fact that
Well, yes.
it's a separate matter but the same.
In the Creel case,
Yes, sir.
in the Creel case, the court decided that the notice was inadequate and that the board heard evidence on matters outside of the scope of the charges, and that decided that was the basis of his decision to apply the Loudermill consideration and dismiss the appeal, reinstate Mr. Creel. Frankly, I hate to ever criticize judges, but you have to do that sometimes. He doesn't say why, or he does not cite any factual basis in his decision of what he's talking about. He just says that the matter was decided on facts outside of the scope of the discipline. I frankly don't remember it that way. But nevertheless, he made his ruling without citing the facts, only the basis for his ruling or the legal basis for his ruling. So, that was one of the reasons I suggested to the parish attorney's office that the city appeal that. So that's where we stand, and that's gonna be something that's gonna come up, over and over again, I believe. So that's one of the things that we want to take into consideration. But right now, we're really down to a consideration, with the evidence that we have that's already part of the record, or the pleadings that are part of the record. We just have to look at 33:2500B and determine what it means. And the facts where you have 3 decisions one day, 3 implementations of the discipline all the same day, and 3 appeals, citing that. And I think I see Kyle standing, and you must have something to say. Why don't you say it?
I'm just listening.
Okay.
He's ready to present his case.
Any questions, board members?
We both have opportunity to speak about it.
Yeah, I think I'd prefer to hear the attorneys first, and then I'd like to have something to say, but right now, I'm not quite sure I understand exactly what's going on.
But we don't have the factual, say in fireman's terms.
We don't have the factual details on what.
Actually transpired.
We do, and that's the whole point of why we're allowed to talk about it. But we do have the factual details. We have everything we need in that Mr. Camelot filed for an appeal, for 3 appeals on one day. So the facts are that he applied for 3 appeals, 1 a 60-day suspension, 1 a 65-day suspension, and 1 a 75-day suspension and a demotion, all to be held concurrently or served concurrently. That's what we're talking about right now, but what we already have. Just to clarify, 60, 65, and 75, which is the aggregate of 200 days. What the question is the legality of that punishment. I learned something within the last 2 weeks. Again, I'm not an attorney, but I learned that if the law, or I was told that if the law doesn't specify, if it's not clear, black and white, that you can or can't do something, then you have to go back to the intent of why that law was written. And obviously, I think the intent here of why 2500 was written, 90 days, is that if you have an employee in the classified service that is not a good employee, and he or she is suspended for more than 90 days within a 12-month period, they don't need to be a part of the classified service. So I get it. I understand the intent of that, but what I don't understand, and I guess the question here is, and maybe we'll find out, is that why would you have an employee that's suspended for 200 days? And why are we keeping that employee in the classified service if they're such a bad employee that you deem them to be suspended for 200 days within a 12-month period? Why are they still here?
So is the actual suspension though 200 days or 75 at a max?
Well, the suspension on paper is 200 days, the aggregate of 200 days.
But they're
Now, it was
but
done.
they're concurrent, right?
Concurrent, which that's also never been done. It's not written in there that you can or can't do it, which is why we have to go back to the intent of.
Well, Maruti, right here it says, in that same suspension without pay for a period of not exceeding the aggregate.
Of 90 days.
You just said 75. He said 75.
It's three differences. It's numbers: 60 days, 65 days, and 75 days.
Please use your microphones.
Hit the button at the bottom. There you go. Right. He served 75 days. He was off of work, but his suspension was 200 days. And again, I've never heard of it. Mr. Floyd had never heard of it. The Office of State Examiner's Office never heard of.
Well, I'm just using the paragraph that he's using, it's saying suspension without pay for a period not exceeding the aggregate of 90 days, which that doesn't qualify then, right? Because it's less than 90 days.
The aggregate means
the period without pay.
The periods together, taken together,
Right.
is 200.
Well,
Aggregate.
is it
means-
200?
But he's not
without pay?
but he's not actually serving that much time.
Correct,
So that's what I'm getting at. He's serving the maximum time of 75 days, since they're all concurrent.
correct.
So that's less than
He's not getting 200 days without pay.
Right, in practical purposes, but on paper, he was suspended for 200 days. And that's what we're discussing.
Well, but we're using B, and I'm just reading, where it says suspension without pay for a period not exceeding the aggregate of 90 days.
without pay.
How long is he without pay? 200 days or 75 days?
I assume 75 days.
Correct. So it's 75.
So that,
So it doesn't, I mean,
so it doesn't apply.
Why was he
As he,
suspended for that?
no, we're talking about a different issue. We're just saying if you're using this to quantify the situation, if the period is less than 90 days, which it is, that he's receiving without pay, then this doesn't apply.
Well, let me ask you a question. What was the point of the 60 and the 65 days?
We have to ask the chief
Right.
what the
The
point
letter
was.
was written that he was suspended for 65 days, he was suspended for 60 days, and he was suspended for 75 days. Now, he was only off of work for 75 days, but that's never happened before.
All
It's
right,
never,
I guess we could deal with that
currency has
separately.
never happened.
But what I'm wondering is why are we using this paragraph if it doesn't fit?
Because it does. I mean, that was the opinion of our attorney, it was the opinion of the state examiner's attorney, it was the opinion of the state examiner, that this has never been done, and that,
Well, we could listen to the attorneys, and, I mean, maybe they could help us understand.
because if he was only suspended without pay for 75 days, then he wasn't suspended for 200 days. So 75 days, then.
well, what do we do with those other letters? He's got to appeal those other ones too. You understand that, right? Like the
Right.
two that he didn't serve, the 60 and the 65, he still has to set an appeal hearing for. So we can't just ball them and throw them away because they're punishment. He has to appeal them. We're going to hear a whole,
So the 75 was just for the first offense?
I'm not sure. I'm not sure the order.
The
Let's-
75, this is what it reads, the disciplinary action. It says, it relates to IA number 1-21. You are to receive a 60-day suspension to run concurrently with the 75-day suspension imposed in 1221, which is a different IA number, and the 75-day suspension imposed in IA 1321. You will be demoted in rank to a corporal, who was a sergeant, and you're required to attend training classes in criminal procedure and procedural justice. So
Can you suspend somebody when they're already suspended?
you can't, well, there is, running things concurrently is very common in criminal matters. I have personally never seen it used in a civil service matter. So that's, we're called upon to answer the question whether or not 60 days, 65 days, and 75 days being given in the same case, at the same date, to the same individual, all within a period of less than 12 months, is that violative of the law, not violative of the law?
Yeah.
As it relates to when it goes into his disciplinary file, everything's operating off of seniority, right?
It goes in his disciplinary file for sure. And it's 3 convictions. In other words, if he doesn't appeal and get this overturned, he has 3 strikes against him already.
in 200 days.
Okay. So that's what it'll show, 200 days?
It'll show that he got 3 pretty steep suspensions. And anything somebody would do after that, you would expect that there would be a termination, you see. So the question is it legal to impose that? If you look at the decisions, which are part of the record, I presume you have a copy, but in each decision, it makes reference to the other, because they were all issued the same day. It makes reference to the ruling in the other cases. So the ruling was done all at the same time, and each ruling mentions what the disciplinary action was, that ruling, and also mentions the other 2 rulings So we're being called upon to render a decision as to what 2500B means in the context of 3 decisions made the same day, 3 impositions of sentencing totaling more than 90 days made the same day, the validity of the idea of using concurrency to avoid the requirements of this statute, and how, how it affects the officer in the future. And in that regard, I'm gonna call to the attention of the board a recent case from the Second Circuit Court of Appeals, and it's the it's the case in Second Circuit, May of 2021, City of Shreveport versus the Municipal Fire and Police Service Board and Officer Payton. And in that case, the court was referring to the effect of even relatively minor things if they become, if they're determined to be an adverse action. And certainly 3 suspensions are an adverse action. The court says it doesn't have to have gotten any suspension. The adverse, but it concluded that simply having a decision being sustained. If you notice that in the city's method, they cite what the ruling is, what the violation is, and whether it's sustained or not sustained. This was a surprise to me, this ruling in the Shreveport case, but they said even a finding of sustained, because it can affect you in the future, gives you a right of appeal. So it looks like to me if the Supreme Court or other circuits adopt this, anytime you have a sustained action, it allows for appeal from that action. So when we talked about how much business this board gets, how long it takes, it seems to be gonna expand dramatically if this ruling stands the test of the, I think a writ has been applied to the Supreme Court. But the case is for the City of Shreveport versus the Shreveport Municipal Fire and Police Civil Service Board and Officer Orlando Payton. The reason I bring it up now is because it gives some credence to the idea that if you have a finding that you were suspended for 60 days, a finding that you were suspended for 75 days, and a finding you were suspended for 60 days, that all 3 of those are very clearly appealable. And so how does the fact that they propose to run concurrently affect the implementation or the validity of 33:2500B? And that's the decision for the board to make.
Still have those same
Yeah,
concerns?
I think we just hear from the attorneys. They're both sides to hear what their arguments are as it relates to.
Mr. Kershaw. What are your thoughts on it?
Well, as you pointed out, and I guess the state camera pointed out, aggregate is the sum of the whole. So you take each one regardless of the concurrency. Running concurrent for 75 days.
Is your microphone on, sir?
That's a little
Button at the base?
at the base.
Okay.
There you go.
The, so when you take the aggregate, you're supposed to add them together. And obviously it's more than 200 days, so it is in violation of 2500. The running concurrent does not affect the aggregate nature of the sentence.
Yeah. I go back to what Mr. Williams was focused on. If you look at the statute very specifically, it says may extend a suspension without pay for a period not exceeding the aggregate of 90 days in a period of 12 consecutive months. When Chief determined that he was going to run this concurrently versus consecutive time, he made a distinct decision not to terminate the individual, but to run his time that way, so that in his IA file, does he have 3 sustained cases? Yes, but they specifically say that they are running concurrent with each other, so the total period without pay is 75 days. So because of that, I think it fits within the statute, okay? But I think also that if you disagree with that, and you decide that you don't like it because it's 200 days total, and we're not going to worry about the fact that it was running concurrently, you have a few options. One is, I think you can read the statute how we read it, and I think it's safe to go forward with it as it is. 2 is, he's got more than 90 days, he's terminated. That's another way to read that. 3 is, you send it back to the chief to reconsider the ruling. And the chief did not intend to terminate this individual, so I think if you decide that you don't like the 200 days, I think the most appropriate thing to do would be to send it back to the chief to allow him to reconsider that decision.
I guess that would be considered under such other less drastic actions may be appropriate under the circumstances. So was this less drastic than the termination?
Of course. Absolutely.
Thoughts, Mr. Purcell? Of those 3 options that the board has?
Can you repeat the options one more time?
Sure. The first one is that he was only suspended for a period of 75 days. So what was done to him, the discipline was appropriate under the statute, under a plain reading of the statute. I think that's your first option. Number 2 is it's more than 90 days. It results in a termination. That's your second option. Your third option, I think, is to send it back to the chief to reconsider his ruling.
And our 4th option is to vote to overturn it completely.
But let me speak to that, because you can't overturn a case and say you haven't heard the case.
Well, based off of what we have seen and the fact that the legality of it's in question, we don't have to hear.
But
why are you arguing? We've seen it. We don't need to hear your argument about it. We don't need to hear any of this. We have what we need in front of us. If we believe or deem that to be illegal, then we can make a motion on that, or any of us can make a motion on that.
Right. There is nothing in the law that allows you to just brush aside a sustained violation.
But what there is in the law, if you don't agree with what we do, you can appeal that to the 19th JDC and get judicial review in it.
And certainly we would.
Right.
But in that
There's a
situation,
mechanism for you guys to appeal what we do if you don't.
no, it's imperative for you to get it right in the first place.
I agree with you, and we'll have a discussion as a board about that in a minute, of getting things right. But that's my exact intent, is to get it right, so that if it's scrutinized at the 19th JDC, that we're not, 1, wasting taxpayer dollars, 2, wasting our time, and 3, burdening an employee any further than we need to do.
If I may say, what you are challenging is a penalty.
What?
The penalty.
Correct.
You are not challenging the ruling of whether or not there were a violation of policies.
Correct.
Okay, so dismissal would be if you were challenging the ruling,
I disagree.
not the penalty.
I disagree.
The penalty would simply mean that the potential actions that were suggested. The penalty would simply mean, well, we disagree with it, send it back. We disagree with it, we think that 200 days equals a termination. We agree that it doesn't violate that it's just the penalty that you're talking about. You have to hear factual evidence to challenge the ruling.
We're challenged.
Because you have to hear the evidence upon which the ruling was based. And then you can say, oh, well, the ruling was improper and we would dismiss it or we disagree with it. But the ruling is not before you. You haven't heard of any facts to substantiate dismissal. all you're really talking about is the penalty, not the ruling.
Please do.
It is absolutely within the board's right to separate the whether or not discipline is even required based on the actions or inactions of the officer and the actual discipline that was rendered in the case. There is plethora of case law allowing the boards throughout the state, the civil service boards, to separate those two issues. Those are what you decide when you go to a hearing. You hear the facts of the matter and decide whether or not this is worthy of discipline. And then the next thing to decide, well, hand in hand, is was the discipline worthy of what was done? Plenty of case law on that. In this, how many times have I been before y'all filing a motion for summary disposition where we're arguing issues that, should they be granted, the whole case gets kicked out before the first witness takes a stand? Plenty of times. That happens all the time. So it absolutely is within your right and authority to consider this, and if you consider that this discipline that was rendered is in violation of the law, it is completely within your authority to act thereon and render a verdict as to just the discipline without having heard from the first witness.
Whenever you have motions for summary disposition, it's typically related to some alleged violation of the officer's Bill of Rights.
Yeah.
This is not in the officer's Bill of Rights. The officer's Bill of Rights does provide for specific things that if the chief were to violate those things, the case is a nullity. This does not specifically give the board the right to kick a case out because of a perceived violation of it. Okay, that is not a right of this board in this situation. This is not a part of the police officer's Bill of Rights. This is an ancillary constitutional rule.
What
So,
gives the officer's Bill of Rights its teeth? What makes it
the legislature.
state law, right?
Yeah, but it specifically,
State law that we're talking
it's different, okay? It specifically says in the police officer's Bill of Rights that if you don't follow this, this is a nullity. That does not say it in this statute. Words have meanings. Okay, we learned that in law school. You don't get to just add words to statutes where they do not exist.
Yes, sir. The question that the board has to consider is, do we think that, I'm going to reiterate, or not reiterate, but I'm going to go through some other options. I think our one option is to disagree that this is a violation of the state constitution and that we hear the evidentiary hearing and schedule it for a later date, 3 hearings. That's our first choice. Our second choice is to send it back to the chief, and I'm not sure about the legality of that. We'd have to check with counsel to make sure that we can even do that. We're not allowed to make a determination because we're not allowed to increase punishment, is my understanding of our job as a board. And then the other one would be to dismiss the case because the punishment violated the state constitution and the law. This is something that I think warrants our time to discuss as a board without interruptions from council, obviously. And we need to come to a decision, and a motion needs to be made, and we need to vote on that motion today. My issue with it is, once Mr. Floyd and once the state examiner and her legal counsel advised me that it was against the law, in their opinion, these are 2 independent people that have no dog in that fight. They said they thought it was illegal. I weigh that 100% and completely. And once we are advised of that as a board, I think that we are sworn an oath to uphold the state constitution and the law. We have to look beyond favoritism. We have to look beyond our personal feelings of individuals, whether that be the officer or the chief or the chief's attorneys or the mayor or whoever it is. We have to do what's right by the state constitution. And I think what causes things to go so far, I mean, literally that took an hour to discuss because I think we allowed attorneys to step in and start muddying up those waters and putting their spin on things. Whereas if we would just discuss it as a board I think we would come to a conclusion that hopefully is fair. Something else to consider is that since we have been advised by our legal counsel and a state official and their attorney that this is against the law, or the spirit of the law, not the spirit of the law, I'm sorry, but the intent of the law, I think that by voting to hear the case, we are opening ourselves up, either individually or as a board, to liabilities and susceptibility, one, to removal from the board. And I don't know what other liabilities a board could have. I don't think we can be sued as a board or sued as board members. But we can definitely be removed from the board should the public deem that necessary.
Well, that's true anytime, in any decision that we
Correct.
make.
This is a great point. The fact that we're making decisions, you made a comment once, Dr. Robinson, that we shouldn't make our decisions based off of what 19th JDC would do.
Absolutely.
I disagree with that. Because 19th JDC is going to consider judicial review unprejudicial. They're going to be unbiased in anything that they do. So if we continually waste the taxpayers' money by making the wrong decision and causing this to go before judicial review and then to the First Circuit Court of Appeals, we haven't done our job and upheld our oath that we swore to.
I agree with you, Mr. Chairman, but my statement was intended to indicate that we not worry about whether there's going to be an appeal to the 19th JDC, and that we based our decisions on the information before us, regardless. Not that we don't listen if the JDC rules against us and say that we made a mistake. We certainly take that into consideration. But we shouldn't worry about the fact that somebody may appeal to the JDC. That's all I meant. And so when I make a decision, it's based on what I hear, what I see, and what I believe to be the case in the individual situation, not what JDC might do. And that's what I meant. In this particular case, though, I certainly think that we should listen to state examiner, to our attorney advisor. But my question is whether I really believe that there's a violation here. Sure, aggregately, it adds up 200 plus days. But in fact, there's only a 75-day suspension because that's all he served. So I'm not so sure in my mind that there's a violation there. And until I'm convinced that there is, I don't see that I can vote to do anything other than continue to talk about it and come to some kind of conclusion. Right now, I'm not convinced that there's a violation. I'm not saying that it's not. I'm just not convinced that there is one. So I want to hear some more from what other board members think, and then we'll see where we are.
Again, I'd like to say that if I go back to the wording of the statute, it says the suspension without pay for a period exceeding not an aggregate of 90 days. So if the Baton Rouge Police Department is not paying him in excess of 90 days, then we have an issue. If they are paying him for less than 90 days, we do not have an issue. Based on the statute that will provide me as a reason to throw it out.
Ms. Lewis, Mr. Smith?
I agree. If I read this, turn on your microphone, please.
I agree. I would have to hear more, but according to what I've heard so far, he's only served a 75-day suspension. Where is it said that he cannot run it concurrently? I mean, I would have to hear more on that. But right now, I don't see where there was anything wrong with what he's doing, because it was less than 90 days.
When he goes to get promoted, though, it's going to have 200 days on there. And that's why Mr. Floyd brought up that's part of the punishment was the sustained complaints and the fact that on paper, now a sustainment of a complaint is only on paper. It's just like these 60 and 65 days is on paper. So it does negatively affect him. Sure, he only served 75 days, which has never, in my knowledge, or the state examiner's knowledge, or Mr. Floyd's knowledge, has ever been done before. If your intent, my problem with it is, and I said this from the get-go, if your intent was to have him out of work for 75 days, then impose a 25, 25, and 25-day punishment. If that was your intent. So I just don't understand what the point of 60, 65, 75-day suspension, but we're only gonna have him off for 75 days, or not be at work for 75 days. I don't understand the creativity there, why we would do
Can we
that.
ask?
I would like to know that too.
Sure,
Why
you can
did it-
ask, but all we're
why
doing
was
is
it done on the
extending this
same day?
meeting. I'm sorry.
Why was it done on the same day? Why was that ruling? Is there something that we don't know about why that was given on? So I would like to know.
Why was he suspended in this case for 60, 65, and 75 days? Was it two different hearings, or was it
Yeah.
all done the same day?
There were 3 different cases heard on the same day. The facts of each case determined what the chief felt would have been a sufficient penalty for that case. Recognizing that he didn't want to terminate this individual, he decided that the penalties should run concurrently, but that 75 days would be the max. That was the decision. But the decision for each individual case is a factual circumstance, as I mentioned earlier. It was a separate ruling. There was a separate ruling of violation for each case. Okay? That's why I make the point. And counsel even made the point. The ruling and the penalty are 2 different things. And yes, you do have the authority to determine each. But the point of the matter is you have to know the factual basis for the ruling before you can determine anything.
Since part of the problem seems to be that we were worried about the 200-plus days in future action, maybe against this particular employee, does the chief have the authority to suspend a portion of the punishment so that it falls below 90 days?
Well, he could certainly do that. I mean, your question is, how does it impact a future action?
Yeah.
That's what I'm hearing, right?
That's what
You
I'm.
want to know, well, first question is, how does 75 days affect the future action if it happens? The policies and procedures have an outline, and the outline relate to the number of offenses within a certain period of time. The severity is determined by if the penalties, or rather if the policy violations occur within 1 year, if they occur within 2 years, if they occur within 3. So yes, if someone has 200 days and then within that same year he has another offense, or say a category 3 offense, then yeah, he could be terminated. But it's the same effect if he had 75. Same effect. Okay?
Why wasn't he terminated? He would be terminated then if he had a 75-day suspension, and then later on, within that 12-month period, he had another offense that he deemed a 65-day suspension. That would be over the 90 days, so he would have to be terminated. Well, my question is can you run 3 separate suspensions concurrent? Does that violate civil service law?
We believe you can. Obviously, Mr. Falcon and the examiner believe that you can't. We believe that the language is such, as Mr. Williams said, it deals with whether the factual basis of did he actually serve in the aggregate 90 days, and he did not. And we intended that he not serve 90 days in the aggregate. That was the
Why
intention.
wouldn't you charge him with 3 separate offenses and just give him a 75-day suspension instead of 3 separate instances to where it would go over 200-day suspension? Why wouldn't it just, if it was all the same day and we were charging him on the same hearing, why wouldn't you run all 3 of the charges concurrent with a 75-day suspension? Why would you do a 60-day a 65-day and a 75-day suspension to run concurrent. What's the purpose of doing that?
Because the facts of each case were different, but they merited, in the chief's eyes, that length of violation, okay? When he saw the facts of each case, he said, that looks like a 60-day violation, that looks like a 65-day violation, okay? But he saw value, I think, if I remember correctly, he said, I see value in you, I do not want to terminate you, which is why he ended up running that concurrent.
Ultimately, the questions you are asking are what factual determinations merited a ruling and subsequently a penalty. So,
That's,
you're asking questions that, were there a full hearing, you'd know. That's what I'm saying when I refer to the fact that you can't dismiss without knowing the facts.
well, this is what does it violate state law to charge somebody with over 90-day suspension with a 12-month period?
We don't believe so because it talks about the period that they're without pay.
It says it right here.
Right, I've got the language in front of me.
So,
A suspension without pay for a period not exceeding the aggregate of 90 days. So the period that he's without pay is 75 days. When he's going forward with seniority, it's going to be 75 days. It's not going to be 200.
That's what we just said, Rob. That was the question I asked. What would he be penalized if it's based on seniority? Would he be behind 75 days or 200 days?
75.
Well, see, we have a difference.
It's going to be the period without time, without pay, and it's
Can we
75
get
days.
clarity on this? Because
Actually, he would go back 200 some odd days in the seniority.
No.
Yes.
75.
Would, because he's got 3 ruling letters stating 60, 65, and 75 days.
It's the time lost. That's what determines how far he can go back, and it would be 75 days.
State examiner, they're gonna tell you that he got backed up 200 plus
They did.
days in his seniority.
They did say that.
Okay.
So, did you ask that question? That is not as understand the question you
It's a
asked.
question of how many times can you be demoted, and I think the way that it was written, it's kind of funky, but the way that it's written is each letter says end of demotion, so it kind of looked like he was demoted 3 times.
Well,
So, like,
first,
he can't be demoted.
first, what question did you ask?
Is this legal, this punishment? And the answer was no.
Well, that's not what you just said. You said you asked something else. You said you asked what was the effect of this on the employee's promotion.
I also asked, which one would the board recognize? The thing that came, whatever suspension came in a PAF format, and could we only stick to that and recognize that as a board? Because
Well, perhaps you should tell us everything you
hypothetically
asked.
speaking, well, I am, it's not legal. My opinion and their opinion was that this punishment wasn't legal at all. But that we have to recognize all 3 of them, which just goes to the case that it's 200 days. We have to recognize all 3 ruling letters. We don't recognize what comes in the PAF.
is it not legal based upon this statement? Just on section B, is this what they're using to say it's, so we don't have an opinion
But we,
on this matter?
Mr. Floyd had the conference call with the attorneys in length. I spoke with the OSC and the legal counsel at a different time, but
Mr. Floyd is who presented us with this information and cited B. So I'm understanding that B is used as a litmus test as to whether this was legal or not, unless it's other grounds that we're not talking about.
understand, are there other grounds that we're talking about? I mean, we're talking about.
Section B, which makes this process
We're just
not
talking
legal.
about whether or not 33-2500B prohibits imposition of sentences, the aggregate of which is greater than 90 in a 12-month period. That's what the statute addresses, and that's what the board needs to decide. And
Say it
it's
one.
like any other motion for summary judgment or summary disposition. We have the documents in the record. We have an issue to be decided. It's a legal issue. It's not a factual issue. Can the chief impose more than 90 days in suspension in a 12-month period?
No, that's not what you're saying. That's not what it says. What it says is not whether he can impose a 90-day period. It says if he can be suspended without pay for a period not exceeding the aggregate of the 90 days. Again, we got to read what's written in front of us. We just repeated something that was changed from what we read.
I was just informed by Mr. Floyd, we can't request judicial review in this matter. I assume that if we choose to dismiss this, you guys will appeal this to 19 JDC, correct?
Absolutely.
Okay, thank you. Mr. Kershaw, if we choose to hear the evidence in this case, it's not going to be till 2022 when we have an open date. Are you going to appeal what we do today to the 19 JDC as soon as possible to get judicial review on our findings or on our decision?
I guess it would depend on what the ruling is, but yeah.
Well, I'm saying if it goes to hear the evidence and hear a case and schedule a hearing. Okay. So either way, we're going to get a judge to deem.
Whether or not we should hear it.
Right.
Well, maybe that's what we need, because, you know.
I agree with that.
Yeah.
I mean, I was satisfied with having the outside counsel and the outside OSC give their opinion. Obviously, the board members are not.
But Rob, if you're asking me to make a decision based on the information that's handed to me,
Right.
and I read the information, and then counsel makes another opposing statement that does not match what's in the statement, I mean,
I'm also asking you to take in consideration the Office of State Examiner's opinion and their.
I don't have that. I don't have that. What I was given was this, saying, this is what the state examiner said, we're gonna uphold this law.
No, that's just the law. That doesn't have anything to do with what the state examiner said. Although I had a conversation with them, I reported what the conversation was. But they don't make the law either. This board decides. And that's why it's before the board on a motion for summary disposition. You can vote yes, no. For instance, if you vote, well, if the first one that comes up is the 60-day suspension, the issue is gonna become, and that is sustained on appeal, the punishment. He does the 60 days, and then we have the next hearing. And on the next hearing, it was 65 days. I believe we would be limited to an additional 30. It would have to be reduced to 30 at the maximum, you see, to make a total not more than 90 in a 12-month period. But I don't get a vote. All I do is, the chairman asked me my opinion, and I suggested we talk to the state examiner, and that's what we did. And we told y'all what we did. I don't vote on this deal.
And I think you're right, Mr. Floyd. And to me, I think I would feel a lot better about this if we took the position that you indicate. If we do the 60-day first, and we let's say we uphold that, then in the second one and the third one, we make sure it doesn't exceed the maximum. That's fair.
That may be a reasonable way to do it. I thought, my thoughts were, not anybody else's thoughts, my thoughts were, if we heard the case and we decided there was a basis for the decision, but the penalty was excessive in the first case, the 60-day case, and we reduced it to 30. Then we heard the next case, a 65-day suspension. I think we would only have the possibility of imposing at that point
60.
Less than 30.
60 days.
57.
total.
57.
And then after that, if we heard the third case, and suppose we reduced it to 30, so we have 30, 30, and then we, to the third one, on the third one, we'd only be able to do another 30.
Right.
So, for heaven's sakes, I'd like y'all to know, I asked Mr. Raines, can y'all get together and try and work this out? It's something that's gonna have to go to the Court of Appeal.
But
I understand that.
What-
Whoever loses is going to the Court of Appeal in this case. I said, why don't y'all try and work it out? They did. They had a lot of discussions, and I'm not gonna get into that. I wasn't there. But it makes sense in this case, whereas it's not clear, one way or the other, if it could be resolved through some negotiations, that's the best thing to happen.
Absolutely.
But what kind of precedence would that set with us limiting our ability to, okay, we're only dealing with the 25 days of the last, what if the last case is the most egregious?
Yeah.
So we set a precedence that's gonna be a problem for us.
Not really, since the total is 75 days.
What we-
Anyway.
But we're going in with a prejudice of how many days that we're looking at total.
The state law tells us how many days in the aggregate.
That would be my suggestion, that we hear it.
It sounds to me like you would like to hear all three cases. You'd like to hear the evidence.
I would.
But that's saying then you disagree with the punishment or the way it sits right now, the ruling. You believe that that falls within the law.
I believe it falls within the law.
What does?
The ruling, the 200 days falls within the law.
I'm reading, I would agree with him, because it says the suspension of without pay.
Right.
If somebody wants to stand up from the police department,
Please no more. Let's keep this within the board.
well, my question is, how many calendar days is he gonna serve without pay?
75.
Then it's within the law, based upon what I have
Your
in front of me.
opinion is that.
It's not my opinion.
Ruling,
It's not my opinion. I'm stating.
of course, it's your opinion, Brandon.
All right, yes. it's
Ms.
my-
Lewis, is your opinion that the 200 days aggregate falls within the law? The way the ruling sits right now, that is legal and abides by the state constitution and the intent of that law?
I agree that when they say, when I'm reading, may not extend suspension without pay for a period that not to exceed 90 days, and his suspension without pay is 75, I agree with that.
Okay. Mr. Smith?
I do not.
I do not either, and then please say why you don't agree.
Well, because it's 200 days. I mean, it's 3 separate cases to be served under one case. I mean, you can't do that. It's not legal to,
Can you?
even to hear it, because, all right, why are we gonna hear the other 2 cases when he already served the punishment for the 2 cases? I mean, why would we hear them even? I mean, all right, what if we decide to give him his time back or overturn their decision? It was too late. He already served a suspension of it. I mean, he's already served the penalty. You can't, I mean, I just don't think you can run something concurrent. If you're gonna suspend him for more than 75 days or 90 days, fire him. But he didn't. He thought it was worthy of him. So why not do all the charges under the 75 days? That would have made one case, one hearing, everything. But this way, we can't, you're gonna hear the 75 day now. Next May or whenever, we're gonna hear the 65 day. Well, he already served his penalty for this charge already. So, I mean, why are we even hearing it then?
How does he seek relief for the other 2?
I mean, yeah, he's already served it. He's already served his charge. He already went to jail for 75 days. Well, whenever we
Say
hear,
the 60-day, and we say it doesn't rate a 60-day suspension, let's give him his days back. Well, he doesn't get his days back because he's already served
served his
75
jail
days.
time.
So where's his relief?
Relief is that the department will have to pay him for those days that we reinstate.
But your argument is that he only served 75 days, and we haven't even heard the 75-day case yet, right? But we're gonna give him back 60 days of that 75 days.
all right, when you hear the next case, you're gonna give him 65 days back of the 75-day suspension?
Right.
Which that'll be 125-day back pay when he only served 75-day suspension.
I think it's obvious you could see why concurrency isn't included in civil service, because you can't, there's no,
You're not running nothing concurrent.
right. We can't give him relief for the 60 days. If we find him to be not guilty, we can't give him relief. The only thing that goes away is a piece of paper, it gets balled up, thrown in the trash, right? But that's the same thing we're saying now. That piece of paper is what, it's 200 days of suspension. It equates to 200 days of suspension.
But he only gets relief.
He gets no
If
relief.
this- Well, I mean, if this board decides that the punishment is less than 75 days, then there is relief. If we do not decide less than 75 days, there is no relief
On the 75-day.
on anything.
Okay, explain this to me, Dr. Press, if he comes before the board and appeals his 60-day suspension.
Okay?
And we overturn it and give him 60 days. What's his relief?
But I think we
He
already,
has no relief.
That's what I'm saying.
My-
He's got no relief. There's no, he's got nothing.
but Rob, but that was my point in saying that we were prejudiced in what we were already starting out with. When we began to listen to the hearing, we're already capped out at 75, regardless. So we can't give him 60 days if we're capping out his whole punishment at 75 and waiting for all three of his hearings. That's why I said we're setting a precedence to where we'll have to, if somebody else says, okay, I have multiple cases too and I need the same thing, then now we're gonna have to do, you know, it doesn't matter how egregious the third one is,
I'm not understanding that. Let's say somebody has in the normal way that it's supposed to work.
but this is not the normal way.
Correct.
So we're dealing
That's
with,
what we're
when we're saying, we're capping out at 75. He can't get any more than 75 days based upon the discipline that's been rendered to him.
Right.
All right, so the 60 goes away. There is no 60.
No relief.
So we don't even have to hear that case then.
So yeah, why are we
Dismiss it.
hearing the 60 and the 60?
What I'm saying is, we're having, if we take that route, we'll have to meter what is 60. He can never get 60, and us have an expectation for us to get to the third procedure. We can't get to it.
Can't,
It's a mess, which is why we need to
can't
make
get
a
to the
decision
second
now.
one because he's already served the 75 day for the 65. And then he served the 75 day for the 60. So you can't, I mean, what's the point of hearing it if it's already did the penalty? What's
One
the
of
point of the
options was
appeal?
Kick it back to the chief. What was mean?
What is the
This kick it-
legality of kicking? Now, he gave us a great compromise in all this, although I mean, I'm for dismissing it because I think it's against the law. It was explained to me. I wish it could be explained to you. I wish that,
It was explained to you in a way that it wasn't written in the law, which doesn't make sense for me to say that I can agree with you unless I have something that
okay.
backs up what you're telling me.
We're afforded with a compromise here.
Yes.
Should we want, but I need to know the legality of that. Obviously, a new Laudermill hearing cannot be had, correct?
No, I think they can do it. I thought if it gets kicked back to the chief, I don't think it's the end of this case.
No.
If a summary judgment is granted, I think it goes back to the chief. There's no double jeopardy that's attached to anything like that. He would do it and he would make a decision. And I would hope that after hearing all of this, his decision would not, if he finds him guilty of all three things, it would be less than 90 days. But that's up to the
That's
chief.
the right way
But
to
I
do it.
believe this is wrong because of the effect you have multiple convictions
Under one penalty.
under one penalty. That's wrong.
So you indicating then is,
So we can-
you would recommend that we send it back to the chief?
I'm curious to know what would happen if it's sent back to chief.
No, but
At what point does it restart? I mean, legally, I don't feel like you can reissue a pre-disciplinary letter
I think it's just a reconsideration of the ruling.
of the ruling. So it would go strictly to the chief, what he knows, and he would redistribute punishment. How many days has he served so far?
50 day,
50 today? Okay.
my understanding.
Well, I so move that we send it back to the chief.
I second.
Second by Ms. Lewis. In the spirit of compromise, so that, now, the only part of this that I don't like is that we're getting no answer for this. Basically, we're kicking this can right down the road. I would rather see it go before the 19 JDC to get judicial review and then on to the First Circuit Court of Appeals. However, Mr. Kershaw, whether we put this back to the chief or not, can we assume that you're going to appeal it no matter what it is? No, we can't assume that. If you guys make a deal, okay. And that's the only part of this that I don't like. I want clarity. I want a judge to sit down and clarify this. The same thing I wanted for a letter of caution, which has been done, obviously, now. So this never comes up again.
Let me say this, if the city, the police department would be the loser in this, I have every confidence that we'd get a decision from the Court of Appeal. If Mr. Camelot is the loser in this matter, and he's got to go through and win 3 appeals, and at any one of them he's going to do 75, he's not going to be able to appeal that. I don't think the appellant can appeal the denial of a motion for summary disposition. Only the losing party can appeal that. He'd have to ask for writs, as I think the city and think about it now, which is a much more difficult route to get to what the chairman wants. I mean, I would love to have a decision. I wish tomorrow the Second Circuit Court of Appeals would render a decision on this issue. It's a close issue. All we can do is ask the board to decide. You vote, and we go from there. But if you vote to deny this, then we have to set unless there's a compromise between the parties, we're gonna have to set one of those 3 cases for hearing. We have to have that hearing.
Yeah.
And then on another day, we'll have to have the second hearing. And then if they hadn't used up 90 days by then, we'd have to have a 3rd hearing. But even if we used up the 90 days and he wants to get his record clear, we'd still have a 3rd hearing.
Yeah.
So you are absolutely looking at 3 hearings, a compromise, or send it, a compromise between the parties, or send it back to the chief, let him reevaluate his situation, and see if we can do what, he knows that at least some of the people on this board believe 90 days is 90 days, and that's the golden rule. And maybe he'll make his decision to make it within 90 days. So I think Dr. Press's motion is appropriate.
What was it, restate the motion? To send it back to the chief?
Send it back to the
Send it
chief.
back to the chief for reconsideration.
Consideration of the 3 rulings.
And then we still may have 3 hearings. You know, we still
Right.
have 3 hearings anyway.
We still gonna have to have 3?
No, we might. It depends on what agreement they come to. If they come to an agreement, it's up to,
If they do a consent discipline, then we don't.
correct, hopefully, or we'll see. I don't-
Other than that, we got 3 different ones. Right.
I am all for the consent discipline. I am all for that. I think it's a win-win for the taxpayers. I think it's a win-win for us. I think it's a win-win especially for the department. But if that happens, my only concern here is if that happens, we're not gonna get an answer to this. Meaning, if they consent discipline, if they agree on a certain amount of days, there will be no appeal. Meaning, we will not get judicial review. We will not get an answer to our issue here, which is.
One thing.
Our issue goes away.
The board, fire and police civil service boards across the state have been in business for about 70 years now, and they hadn't done an opinion yet
Right.
on this particular issue. I think the only one that's likely to come anytime soon is this case.
Right.
If it goes that way, but the case could be resolved before then.
Which is my only concern about sending it back to the chief. I
Can
want it to go back.
Can
to
we
the
ask
chief,
for the Attorney
100%.
General's opinion?
The Attorney General?
Yeah.
It's not binding on the boards.
That doesn't help.
We have no procedural issues to worry about.
Because I too would like to have an answer to the question, but,
Get into it
yeah.
either way.
But I just don't think that the written law says that the chief can't do what he did. So, that's my dilemma.
Chief,
Deny it.
can I ask you a question real quick? Please?
He would determine
Can I get you to come to the podium? I want to ask you a quick question.
if it was legal. And then
So you're saying-
if it was legal, then he'd push it back to us for us to make a decision on all 3 cases.
Thank you, sir. It's obvious your intent wasn't to terminate Mr. Camelot. I'm not sure, and I don't want to ask you what your intent was by imposing the 60, 65, and 75 days. My concern in sending it back to you is that, again, we're not going to have closure. We're not going to have a verdict on whether or not serving punishments concurrently is legal or not. That's my only drawback. That's the only reason I don't want to vote for sending it back to you. Is there anything you can say to guarantee that we won't see another concurrency violation? If it's a violation that rates 15 days, the aggregate of 75, let's not confuse it. Let's keep it black and white.
My word. I think my attorneys hear you loud and clear. We are listening, just like every time we have a hearing, we go back and we discuss it. I don't think you'll see any type of ruling that would generate these type of discussions again in the past. You have my word on that.
That's all
Okay?
we needed to hear. Thank you, sir.
Thank you.
I am prepared to, I'm sorry.
So if we overturn or rescind the chief's write-ups and they appeal it to 19th Judicial, we would get judicial review of it, right?
Which is why I would like to make a decision either way. The one way that doesn't get that judicial review is allowing it to go back to the
Go back.
chief, and then they can come into some agreement, which, after speaking with the chief, I'm fine with voting to send it back to the chief, me personally. Right, it's seconded, we'll do a roll call vote, but I want to make sure everybody has an opportunity to speak first.
Okay.
And get a clear thought, and then I'll clarify the motion and we can vote. Is there anything else from anyone?
What you saying, John?
You could amend the motion, can't you?
We could, but I think for the benefit of the community,
Okay.
taxpayers'
We'll do that,
dollars,
yeah.
the department, hopefully the employee, I haven't heard an objection, to send this back, well, I haven't asked, sorry, to send this back to the chief and let him reevaluate the ruling.
Then we could do.
You want to?
Yes, I'd like to hear that objection. If you have an objection, would you object to me voting, I can't see the board, with my vote to send this back to the chief for a reevaluation of his previous ruling?
I think that'd be completely y'all's decision.
Of course,
I don't know that there's a procedural vehicle for y'all doing that.
That was my question, Floyd. Like, do we want to do something that would procedurally give us an issue?
The matters before the board today, we don't have to have the hearing. Hearing can be continued and let's see what happens.
So are you saying if we go down the route to resend it to the chief, it may be an
I
issue?
believe it, look, the Court of Appeals, the 19th Judicial resends stuff back to us all the time. I don't know of any prohibition against us sending it back to the chief for further consideration. I don't see an issue with that at all. To me, it's really kind of simple. This really needs to be worked out, because in the thousands of cases that's been before the board, it hadn't been decided yet. We can, depending on what we do, maybe in 2 years, getting a decision from the First Circuit Court of Appeal, about 2 years from today. About 2 years from today, don't you agree with that?
Well, but does this become like a 19th JDC where we reconsider issues all the time?
Yeah, it's just the same thing. We're asking the chief to reconsider his disciplinary action. Seems like he's willing to do that. I don't see anything wrong with that.
I think it's a win for everyone.
I think so. That'd be good.
It just
I
doesn't
appreciate
give
what
us
you
an
said.
answer to
I
our question.
very
But
think it's the right thing to do, and I think
That sounds good. So restate the motion again one more time.
motion is to send the issue back to the chief for reconsideration.
So your vote of yes is to send these 3 letters or violations back to the chief for him to consider his ruling and amend his ruling. A vote of no is proceed with the hearings and on a future date, all 3 hearings on a future date. Ms. Penny, roll call vote, please.
Brandon Williams,
Yes.
John Smith,
Yes.
Sharon Lewis, Russ Robinson,
Yes.
Rob Maruzzi.
Yes.
Motion prevails, 5 yea, 0 nay.
This matter will go back before the chief for his consideration. I would like to give the public an opportunity to speak at this time.
Good afternoon. My name is Jennifer Carwile. I have several issues that I'd like to speak on. I thought maybe we would have a chance to speak before the hearing, so not everything is relating to the hearing. Can you hear me okay if I keep on my mask, or should I take it off? Okay. First question is, we read in the paper that Mr. Falcon had stepped down, and Mr. Falcon's here, so I was just hoping there was some clarity about, did Mr. Falcon rescind his stepping down, or is there?
I think it was effective August 31st.
Okay, all right, thank you. Then we all understand people need to be compensated for their time. Some of us sit here for 12 hours, with not even the Jimmy Johns. So we appreciate that. The suggestion is that there needs to be some parliamentarian action. Mr. Marzzi is giving a lot of opinions, but Mr. Falcon is the attorney, so we would like to hear more, and I'm really happy to hear that y'all are talking about how we can make these shorter, but there's got to be some parliamentarian Robert's Rules of Orders, and this is not law and order. And I've been thinking of this for 3 years now, sitting there and hearing these cases get longer and longer and longer and more drawn out. This is not law and order. This is a hearing, and I think Mr. Williams has brought this up before, that state the facts that we need to hear to understand. We don't need to go into every tiny detail. I know that's good TV and that might be good court cases, but it's not useful for this. And so I hope that y'all can come to some agreements about that. All right, my next comment is, I know.
Carlisle.
Yes, sir.
Carlisle, let me, since you're on that subject.
Sure.
Sorry to interrupt your flow.
No, that's great.
I intend to speak with our legal advisor, and very rough draft, intend to impose a time limit on both sides for every case. That way, the only part that I can't hash out is cross-examination. I think it's fair to have a cross-examination. I think that by implementing a time frame on both sides, let's just take an example. If we're going to hear three things in one day, I'd say 2 hours per case, 1 hour per side. That also gives the board an opportunity of half an hour per case to deliberate, and we're out of there at a reasonable hour. That was one consideration I had, but cross-examinations is where I get into my
Sure.
issue, and that's something that I would like to talk. And I think it's unprejudicial on both sides to give them both the same amount of time, but again, cross-examination. How can they cross
I
their
appreciate it,
witnesses?
or at least
So no, it's
coming
definitely in
from
our
the-
thoughts. It's
Okay.
a number one in priority for the next hearing, and we
Terrific.
will discuss it amongst the
Terrific.
board. Thank you.
Another thing is that I noticed that Ms. Chawla has been here for a few weeks. I'm not exactly sure who this gentleman is, but my comment from the beginning is we do have the ability, to live stream from this facility. I asked somewhere along the line, and the city said there's never been a request for this meeting to be live streamed, so I'm officially making the request. I don't know how that gets to the city. But I know folks, especially during COVID, who would like to be here but are not comfortable being here in person, who would really like to see the meeting. So since you're in this chamber, please put forward the request for the city to live stream these as well. Next comment. Last year, the legislature had a committee that was overseeing some things about municipal boards in general, and we sat through those. And Ms. Bordelon said that she was going, a lot of questions came up, and that she thought about doing a training for municipal board members so that you understood the finer details and the hashing out and all this stuff. Has that occurred? If that has not occurred, I strongly recommend that we ask Ms. Bordelon to get on that, because it seems like there are a lot of questions here, and it seems from those of us who've been kind of watching, there are rules. You have a guidebook, but I don't think it covers all of the things that y'all could use to know. So please reach out for some more guidance and training. That's the job. I think that's all I've got today. Oh, one more question. Y'all just talked about an issue that was from June 14, 2021, and it seems like you talked about them coming up in November, or I don't know. It seemed like it was. When is that case being heard? Because it seems like. I'm sorry. This is from the very beginning hearings. I think the item was resolved with the chief, or was the discipline was in June 14th, 2021. And that person's hearing is coming, it seemed very soon. The note I wrote to myself is, how did they get a hearing that soon? Because it feels like things are, so I'm curious.
The way things are falling out right now, like today, we had somebody, an individual that had a slot for a termination.
They resolved it.
Correct, they
Okay.
resolved it, and now that, which I'm sorry, what was the date that we scheduled it for?
I don't remember the date. I don't remember the name. It was June 14th, 2021 was the date that I think the chief heard it.
Okay, and then we scheduled it for, do you have that?
I don't remember. I'm sorry.
Is it November possibly?
November 26th.
Okay, so it's a Cowart motion.
Okay, and that was because of the person who
The dropout in November.
Okay.
Now, we do need to discuss next meeting, scheduling an actual hearing for that date, which we didn't do today, but we'll do that next meeting. We have time, now that that hearing is out.
All right, I appreciate y'all's time. Thank you.
Thank you, ma'am. Anyone else? Anyone? Motion to adjourn.
So moved.
Seconded by Dr. Robinson. All in favor signify by saying aye. Any opposed? I'll see you next month. Thank you all for coming.